Hello viewers, in this lecture I would like to tell you about contract. The word contract is very important and is defined in the Indian Contract Act 1872. When we talk of contract, please be clear that we have to go by the definition given under the Contract Act. Section 1 to 75 of the Indian Contract Act are very important for the purpose of knowing what is contract. Since this is the introductory lecture about the word contract, I would also like to tell you something about the Contract Act in general. Hence 1 to 75 sections deal with only 3 aspects of the contract. That is the formation part, to performance of the contract, and third, consequences of breach of contract. You will never find in the Contract Act section 76 to 123 because sale of goods being a contract in essence was earlier a part of the Contract Act. But with the passing of the separate act, namely Sale of Goods Act 1930, these sections are repealed and the other sections are kept intact. The next section 76 to 123 is section 124 to 147. That is chapter on indemnity and guarantee. That deals with the law relating to indemnity and guarantee. Next is sections 148 to section 181, which deal with bailment, and section 182 to section 238 deal with the law of agency. Again, like section 76 to 123, you will not find section 239 to section 266 because these sections earlier incorporating law relating to partnership are repealed with the passing of the Partnership Act 1932. When we talk of contract, section 1 to 75 are important because it is basic structure of the contract. The rest are specific contracts, and then they apply only in such special contracts. But this section 1 to 75 are so basic, and I would like to say that they are like anatomy, that they apply to all types of contracts. Therefore, what is contract according to these sections is important. 2 important words: agreement and contract. Both these words are defined in the Contract Act. Section 2 of the Contract Act defines 10 different words wherein these 2 words are also defined. Section 10 says what is a lawful contract. And section 11 to 30 prescribes what contributes to the making of section 10. So in my opinion, section 10 is the important section because it is the culmination of all sections 1 to 30. Both the preceding and subsequent sections to section 10 are found in section 10. Since this lecture is concentrated on contract, I would not deal with the other definitions given in section 2 except the word agreement and contract. And according to section 2 of the Contract Act, the word agreement means every promise and every set of promises forming part of each other is agreement. An agreement enforceable by law is contract. Now, what is enforceable by law is found in section 10 of the Contract Act. And section 10 says all agreements are contracts. Please mark it. All agreements are contracts if they are made by the free consent of the parties. 1. Competent to contract. 2. For a lawful consideration. 3. And with a lawful object. 4. And are not hereby expressly declared to be void. 5. It further says that nothing herein contained shall affect any law in force in India and not hereby expressly repealed, by which any contract is required to be made in writing or in the presence of a witness, or any law relating to the registration of documents. Friends, this section completely speaks of what is lawful contract. And if agreement satisfies all these ingredients, it becomes a contract and it is enforceable at law. When we talk of enforceability, the most important part is, what does it mean? The moment we say it is enforceable, you can go to court and get your relief, is actionable. You have a right to performance. Section 10, when speaks of all agreements are contracts, says which type of agreements. The first thing is free consent. What is free consent? That is also defined under the Contract Act which I will deal with separately when the topic of consent is taken up. The second important ingredient is parties competent to contract, meaning thereby who can enter into contract. And Contract Act also specifies who are competent to contract. Next important ingredient is the consideration. Consideration also must be lawful. And what is lawful consideration is also defined under the Act. Friends, all these ingredients make a separate question, and I'll take each one of them separately. This is to tell you about what Section 10 means about contract. When we talk of lawful consideration, Section 10 equally emphasizes that object also must be lawful. And what is lawful object is also, as I said earlier, defined under the Contract Act. Last but not the least is not hereby expressly declared to be void. Meaning thereby, if the Act declares any agreement specifically to be void, you cannot enter into contract because it would not be a lawful contract. While prescribing these essentials, though procedural, law also says that this requirement is also not dispensed with, by providing that by making provision of Section 10, no provision of any other act is repealed which deals with either the document or contract to be in writing, or which requires presence of witnesses, or which requires registration of the contract, like immovable property. Thus, if the agreement satisfies all these elements, it becomes a valid contract. If it is lacking in any of these elements, mind well, this is very crucial. It is not that you can dispense with any one of this. All these elements apply with equal force, and absence of anything would not make it a contract. And if it is not a contract, as I have told you earlier, it would not ensure any right. You cannot go to contract. The latest example is the so-called MOUs. MOUs, if they do not satisfy the elements prescribed in this Section 10, they will not be enforceable. And often, therefore, we see that MOU, when not enforced, nothing can be done. Friends, with this, I would like to tell you that the earlier part of the definition, which speaks of the process leading to agreement, are equally important. I have taken first agreement and contract to have one set of understanding. Now, the second part, the process which leads to agreement. If you go back to the definition of agreement, it speaks of the promise. What is promise? Again, that is important. And section 2 defines promise. What is promise? When one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of that other to such act or abstinence, he is said to make a proposal. Friends, every word spoken with different emphasis is equally important in its own perspective. As it is known, law is never verbose. Each and every word has a precise meaning, even comma and full stop. Once there is a proposal, the next question is what happens to that proposal. Therefore, the second stage is when the person to whom the proposal is made. Please be clear. It is very specific, not general. The person to whom the proposal is made signifies his assent thereto. Again, very important. Signifies his assent thereto. Conveys his consent to the same thing without variation. Comma, the proposal is said to be accepted. Meaning thereby, when a proposal is made for some act or abstinence, and the person to whom it is made communicates his consent to the same thing without variation, in law it amounts to acceptance. And law further defines that a proposal, when accepted, becomes a promise. And it is this promise that is a part of the definition of agreement. Every promise and every set of promises forming the consideration for each other is an agreement. Again, one more word has come in the definition of agreement, that is consideration. But I will deal with the word consideration separately because it is also a separate topic. Thus, contract in law is quite different than it is understood in common parlance. Right from proposal to contract, the journey of the word contract in law is very specific, and nothing extraneous can include or exclude any of the ingredients. Thank you.